Welcome to We Chat Divorce, hosted by Karen Shalhoub, Legal Liaison, and Catherine Shanahan, CDFA. Each episode, we sit down with divorce professionals and industry experts to provide insights and frank discussions about real people, real situations, and real divorce to help you achieve your best life post-divorce. This episode of We Chat Divorce is brought to you by My Divorce Solution, offering divorce financial planning so clients can secure the divorce settlement they deserve. Visit mydivorcesolution.com to request access.
Welcome back to We Chat Divorce, brought to you by My Divorce Solution. I'm Karen Shalhoub, your legal liaison, helping you move through the divorce process with clarity and confidence.
And I'm Catherine Shanahan, certified divorce financial analyst and your financial partner in navigating divorce. I kind of lost my voice a little bit today, but as you know, if you listen to our podcast at MDS, our goal is to help you feel informed, empowered, and ready for what's next.
And today we're leaning into a topic that directly affects the power dynamic in divorce, pro se mediation. Yep, we're going to talk about that term and what that actually means. Navigating divorce without attorneys at the table. We'll also look at how some of the default divorce options out there can actually escalate conflict or confusion instead of easing it.
Okay, Karen, so I know I like Tina, I've met her before, but am I allowed to push back of everything that we keep hearing about in this conversation? Because there's so many times that mediators just let couples who are pro se just make decisions based on data that one party doesn't want to hand in, or data that's a spreadsheet, which I know you love, that is not backed by any documents. And I'm always curious, why are the mediators even allowing that?
Yeah. Or facilitating conversation and not really bringing to light the data, documents, the facts, the accountability, things like that. Well, I can tell you that I'm very impressed with Tina. So I believe any pushback you give will be responded to in a great way.
If
My
you're
projection
listening,
right there.
yeah, if you're one of our listeners, you know that I could say things I probably shouldn't say sometimes, and that
I'm not there to kick you under the table.
Yeah, that's an okay from Karen to me saying go ahead, because a lot of times when we're on with attorneys, she's like, be respectful, be respectful. You can't say that. So I just got the okay, you all heard it. I like her too, so there's probably not going to be a lot of pushback, but this conversation is pretty timely. And we're honored to be joined by somebody who believes in pro se mediation, and she puts kids first, which of course is always our go-to, because we do financial clarity. Our front is it's really advocacy for children of divorce. So Tina Keys is here to help us rethink what support can look like. Let's welcome her to the show.
Welcome to We Chat Divorce.
Thank you. I'm excited to be here.
We're so happy to have you with us today and truly grateful that you're here to explore such an important and overlooked part of the divorce journey. But before we dive into today's topics, I'd love to introduce you to our listeners. Tina Keys is a Florida Supreme Court certified family mediator, a certified divorce coach, and a certified co-parenting specialist. She's also certified in trauma-informed practice, special needs divorce, and high conflict co-parenting. Her kids first and one team mediation models are all about reducing stress and conflict while putting the focus back where it belongs, on real people, not legal drama. Tina is also a part of the advisory board for the Caring Co-Parent Coach program, and she brings both personal experience and professional integrity to everything she does. Tina, again, thanks for being here. We're really excited for this conversation.
Yeah, thanks for the glowing intro.
Of course, that was easy. You got a lot to talk about.
Yeah.
But before we get into our discussion, can you just share a little bit with our listeners about what led you into this work and how your background shaped the way you support clients today?
Yes, definitely. So it's kind of twofold. On the one hand, I have been a stepmom for going on 11 years. I sort of watched the ramifications of that traditional divorce litigation process within my own family, both with the kids, some of the things they went through, my stepsons, the co-parenting relationship, just, some of the dynamics that come out of that kind of two-sided mindset that is present in most divorces, right? So that really is what led me into this, initially into coaching and then eventually into mediation, because I realized that's really where there's such a huge opportunity to influence the conversation and the tone and just the mindset, especially with parents of minor children who have so many years ahead of them still of, coexisting and, hopefully finding their way back to friendship, but at minimum, at least remaining civil for the kids. And I'm a huge believer that the divorce process itself is a huge part of the problem as to why so many families are not civil and coexisting well for the children. So that's step one, right? And then step two of that is my parents split up after 35 years of being together. And it was the most amicable divorce, complete, opposite of most people's situation. They sat down 15 minutes at the kitchen table, divided all their finances of 35 years. And there was something my dad said to me that really influences the way that I view this profession. And I'll never forget it. And he said to me, Tina, if after 35 years together, we can't separate as friends, then I feel like we've wasted our lives. And that was so profound to me because I felt like there are so many other people out there who are looking for a way to do this amicably and they literally cannot find it. And that's really what launched me into the framework, the mindset, the way that I work is very different than most mediation that you hear about. And it's really wonderful to see people be able to come together and overcome their differences and come out of it in a good place. So that's my backstory of why I do what I do.
Yeah, that's good. We all who work in the industry, well, not all of us, but the ones of us who are trying to trailblaze a different way to divorce, have those kind of stories because it's what drives you.
Yeah.
It's not an easy business to be in.
Right.
So to be able to have that perspective goes a long way when you're talking to the people going through it, because you get it, right? You get it.
Yeah.
Yeah, it's personal.
It's
Yeah.
personal.
Yeah.
That's a good way to say it. Yeah.
Right.
Yeah.
I like that. And it creates the energy that you come to the table with, or the mediation with your clients. That's really, really quite incredible. So good
Yeah.
for you. Glad you do that.
Thanks.
So we're going to start out with a legal Latin term. I believe it's important for people to understand what is pro se mediation and who
Mhm.
is it best suited for.
So yeah, so that's basically what I specialize mostly in is pro se mediation. And it's really when two people come to mediation without attorneys present. They're not being represented. That's really what pro se stands for, is they're representing themselves. So, if you go to court, same thing. And if you don't have an attorney, you're considered a pro se litigant. So my process really focuses on helping people who don't want all that intervention in their conversations sit down and come to those agreements that they eventually need to come to in order to get divorced. I would say it's a fit for a lot of people and it's not a fit for a small subset of people. I would say if you are the type of person who is trying to go for the jugular, trying to take somebody for everything they have, you're willing to, you want to win at all costs, you have that sort of mentality, this process is not going to work for you, right? There's ultimately mediation in general relies on two people voluntarily wanting to sit down and resolve their differences, but pro se mediation even more so requires two people to really want to be open-minded, be transparent, and ultimately avoid all of the potential costs and conflict and emotional turmoil that comes along with litigation. It's worth it to them to sit down and say, let's just figure this out to avoid all of that, chaos and mess and expense.
Yeah. My problem with that is, listen, I'm a trained mediator. I've mediated hundreds of cases.
Mhm.
But our process, we don't do mediation, but
Mhm.
we help them get prepared for mediation.
Right.
And, I was just on with a client yesterday and she's going to mediation and I'm trying to go through a division scenario with her to make sure she's prepared. And the husband still has not produced his documents. So I said,
Right.
I said, well, why isn't the mediator collecting this information? She says, I don't know. She's just not making him give it. So I said, you need to send the mediator a note with your spouse. They know about us. They know that she's hired us. I can't go through a division scenario if I don't have his information. And
Yeah.
so she was it just amazes me that, and I hate to tell you this, Tina, but it's not the first time I heard this, right?
Mhm.
They go to mediations thinking they're going to work through this because yes, everybody wants to avoid court, but they're going with unverified data, and
Mhm.
they're walking away really mad at the end of the day because they don't get, they're frustrated, right? And they can't make good decisions, although they want to be in the process.
Mhm. Yeah, I would say, and that kind of speaks again to the type of clients that are a fit for the kind of mediation I do, right? Like there is a level of, as you know, right, mediation, voluntary disclosure, right? You have to be willing to provide all the information and trust that the other person's willing to do the same because nobody's, court ordering you to provide anything, right? It's a different mindset. So, yeah, there is that element. If somebody is going to potentially be withholding information or not being transparent, then that makes it difficult for the mediation process to work, because if you've got one person who's intentionally not providing something, you probably are going to have to go another step, right? And either have an attorney that's going to require, the mandatory disclosure and all of that, or have, go to court and do that. Now, I will say it's not like an all is lost scenario. Like the way I work, I don't do half full day mediations. I just don't believe in that. I think it's ridiculous. I don't think anybody is in their right headspace after 2 hours, let alone 4 hours, let alone 8 hours. And I don't care how good your lawyer is or how good the mediator is. To me, like I have a big problem with that mindset, just from a humanity standpoint. It puts people under immense emotional duress, stress, and they a lot of times don't even understand what they're signing by the end of the day. So for me, I break my process up in 1 to 2 hour sessions. Two is really, I mean, if I go past two, it's very rare. It's in a situation where they really have to expedite things, but usually it's 1 hour a week. So we have space for people to work through a few things, go get more information, come back, and I guess to circle back to your point, the point I'm making is sometimes there may be one particular issue that they can't fully get there on because they don't have all the information or because somebody is being difficult. And ultimately, I tell them at least we can still work to get a partial mediated agreement, and then you can reserve that one issue to work through with attorneys or that one issue to work through with, a judge. But at least we're getting a good chunk of it done that you two can agree on and that you do both have the information on. So that's what I guess I would say to that is it sort of depends. Like if you're going into a full 8 hour mediation day and you don't have all the information, I mean, you're pretty much, it's not going to happen, right?
And I do, not to disagree with you, but in a little way I'm going to,
That's
unfortunately.
fine. Yeah.
Sometimes I don't like one-off negotiations because
Yeah.
even if it's one asset, that one asset trickles down to all the rest of them, or you
Yeah.
lose your negotiation power if one spouse really wants that one asset and
Mhm.
the other one doesn't. So I'm
Yeah.
not really a fan of that unless it's like they're selling the house and they should escrow the money.
Yeah.
Even that's the big one, right?
Mhm.
Or they're negotiating away a pension. Okay, maybe we just quadro it. Like there's some things that you can do if you don't have the data, but I want to know what your role is as a mediator when they come to you and they say, like I had her email her mediator, ask the mediator, does she want you to make decisions without this data?
Mhm.
Because you don't have it. And then like, shouldn't the mediator say, listen, I can't help you negotiate if we can't verify. I know it's voluntary, or
Right.
to your point, it's not, maybe they're a subset at some point. You have to realize that although you come in with the intent to mediate, if your spouse doesn't, you're now have fallen into that subset of people that mediation is not good for.
Yeah, right, exactly. And that's what I would say is my approach, it's called kids first mediation, right? It's this mindset of we are trying to put the kids first. We are trying to both be amicable. It takes a certain type of person, a certain type of parent who wants to do it that way. And again, if you've got someone who's intentionally stonewalling the process or not disclosing information, that's probably not a fit for what I do because I am generally my clients that I work with are very open with everything. That's a big part of my process. We do a lot of the information gathering within the mediation process. So, and that's where, they can really see everything with their two eyes right there. I'm screen sharing, we're writing things down, we're clarifying the list of assets so they even know what they have. So, I would say that probably falls into the bucket of people that aren't a fit for what I do. And that's okay, because there's an
And I
entire
think there's,
industry of people who are a wonderful fit for that.
oh,
Um,
totally.
but I think, Catherine, to your point, like I think the market that's most underserved from my perspective in this entire, I guess, world of divorce or divorce system, whatever you want to call this, are the amicable people who want some kind of guidance. Because what I find is, if you're somebody who wants to go the litigation route, or you want to battle on things, or you don't want to get there, like there's a whole system set up for that, right? And if you are the type of client who wants to be amicable, but you don't want to completely do it yourself, you want there to be some kind of structure around getting to those agreements, it's really hard to find that, because for an end client who is not in the family law world, mediation is so ambiguous. They don't understand what it is, what it isn't, how do I find it? How does this mediator work? Because it's completely different from how that mediator works. And so when you're that kind of amicable middle class family who's looking to resolve their issues without all of that intervention, a lot of times they can't find it. And so you hear about, I think the stats where I am, Central Florida, it's like 70 to 80% of cases are pro se or one attorney, meaning they probably came to their agreements and had one attorney file. 20% of cases are the two lawyer litigation model, right? So
Yeah.
that means there's so many people out here who are trying to do this themselves, or some version of, maybe they hire a company like yours to do the financial side, and then they're trying to work it out amongst themselves or with a mediator. So, I think there's a big subset of people who really need that support, and are really struggling to get it. And so that's what I'm framing my whole practice around, is not the high conflict people, because those people are not my demo, right? Like
Yeah.
there's a huge industry for that, and it's not me. And that's okay.
I mean, nationally, because we're a national company, it's like
Right,
10% of the cases will go are litigants, right? So
right.
I do believe that. But what I want, if you're listening to this, and I am a firm believer of mediation. I
Yeah,
just think that it's the way that you should try to do it. I think you should come through our process so you're prepared financially. It's
right,
not just about gathering documents, it's having them assessed, it's verifying, it's all of that. I think if
right.
you do that, you absolutely should try mediation. But what I don't want you to be afraid of is to back out of mediation.
Oh,
And
100%.
so
Yeah,
many people that start it because they are amicable. Everybody wants to be
Mhm.
amicable to some level, right? And that's why I like that you deal with the kids section, because that kind of keeps you in a recheck. Listen, it's kids first. Let's get this done. But don't be afraid that if the mediator is not able to collect the data from your spouse and you're not financially clear, back out. You
Yeah.
might be that 10% that has to go another route, or by
Mhm.
backing out sometimes and going the litigation route will maybe force your spouse then to get a reality check and say, okay, I'll give it back to the mediator now. Now we can
I
go
was
back.
going to say that. Yeah. Sometimes also if you do that kind of approach where you're like, hey, well, then I'm going to have to go the court route and do all these things, then people become more willing to get back into the conversation and be more reasonable. And I tell people ultimately, like where I am, right, in Central Florida, and it's different in every county, every state, everywhere you go, right? But where I am, you're pretty much going to have to go mediate. I mean, if you file for divorce, you're going to mediation. That's it. It's pretty much understood. The only time they maybe won't do mediation before some kind of court date is if there's like a serious danger to a child, or something's happening that requires, like, we got to go straight to court, right? Um, so like, why not start there? Like, if
Right.
you already have to go there anyways, start there. Like, let's see how far we get. And again, Catherine, to your point, you never then can't go and hire a lawyer and do disclosure, or go through the court or take it a level up. And I have many times clients start with me with no CDFA or financial support involved, and then partway through the process, they're like, one of the spouses is like, gosh, I don't really I don't really know what I'm doing here with alimony. I don't really know how to make this decision with, either alimony or with the house, or what to do. And that's where then I would recommend, hey, maybe you should go work with a CDFA, get yourself one-on-one, if not two-on-one, right? Get yourself to where you feel confident in what we're talking about, and then come back. Because my ultimate charter as a mediator is they have to have self-determination. If they cannot feel confident in the decisions they're making, I can't move forward. And so, like, ethically, by my
Right.
professional standards, right? So that's where I would say, okay, it seems like you don't feel like you're ready to make this decision. What would make you feel more ready? And here's some names that maybe you can look at. Here's my divorce solution. Why don't you see if this is a good fit for you? See if you're able to get the information you need, and then let's come back and try to finalize decisions.
Yeah. So let's talk about that. Best practices to prepare for mediation,
Yeah.
whether it's the parenting plan or the financial plan. Let's start with the parenting plan first. What are best practices? Because I think a lot of people start with, oh, let's mediate, let's call a mediator, let's set up a session. But I believe that if you can prepare ahead of time so that you're starting mediation with some fundamental knowledge, it goes a long way. So how could people, families, best prepare for the parenting plan? Let's just start there.
So for the parenting plan specifically, I think understanding the statutes in your state and how things work, right? I think sometimes, I often will see families where one person, often the mom, wants majority time sharing, right? And then dad wants 50-50. And there is a legal reality, like where I am in the state of Florida, there's now a legal presumption of 50-50. So if you are not educated to understand that, and that takes one Google search, time sharing, Florida, whatever, like statutes. It's not like you don't have to go to a lawyer and pay $500 to get that information, right? It's a basic, but just to understand like what stands to happen if you can't find an agreement. I would also say I often like people to prepare with looking at holidays ahead of time. That can sometimes be I would say one of the more emotional conversations we have with the parenting plan is usually holidays, especially Christmas and, birthdays, right? So trying to have some idea going into it of what you're wanting to do, because if you haven't even thought about it, it's really hard to make any kind of decision on the spot if it's the first time you're thinking about the Christmas holiday in two households. And I've had mediations where we've had to kind of completely stop that conversation and come back to it next time because somebody got extremely emotional and was not able to even reconcile that, two household situation with a holiday. So I would encourage people to really take some time and determine how they would want to handle not just holidays, but also travel. A lot of times parents are not aligned on what's reasonable for travel rules. So making sure that you have clarity, at least on your own, of what you feel is appropriate. I will say first right of refusal is a category that often becomes a point of contention. Can we hire a babysitter without, offering time to the other parent? What are those thresholds? Like that's again, if it's the first time we're talking about it in a mediation, it can be a quick 0 to 10 emotional reaction. So sometimes just having the space to really digest and maybe talk to family members or think it through a little bit can help people be more reasonable in a negotiation. So yeah, those would be the things that I would say probably from a parenting plan standpoint,
I
mostly
wonder
time sharing related.
if a child support calculation should be run first, because I know that in my experience, I know that when a parent wants more than 50-50, the other parent gets really mad. Like, let's just use mom and dad. Hate to say it, but that's a typical way, right? Mom was the CEO of the house and ran the kids, and dad worked great, did a great job. And now all of a sudden he's going to not travel as much and he's going to be around. And that's great. You have an opportunity to reset your parenting skills. But oftentimes it's mostly because of the child support difference. If you have 60% or if you have 50%, and sometimes it's really not that big. It's not as impactful as some people think. So if they knew that number before, would it really help them to be realistic about how their household runs the best?
Yeah, I would say so. It's like a double-edged sword. So my standard practice is to do time sharing first and look at child support at the end, right? I will say there are situations sometimes if I can sense as the mediator that there's a financial component to why the time sharing ask is happening, or why like kind of that stubbornness is happening, then at that point I might, a lot of times I'll punt on that and come back to it after the child support conversation. So this is why I feel like my process is so much more palatable for people, especially who are pro se, because we talk about something for an hour, we leave, we come back, we talk about the next thing, we leave, we come back. And so now if we get stuck on time sharing, that's okay. We can highlight it and let's come back. right?
Mhm.
And we can still make forward progress. And it gives sometimes just taking 3 weeks between conversations changes a lot of perspective.
Mhm.
Sometimes once we're a month or two into that kind of week-long process, um, people don't feel as positional as they did in the beginning, or they
Mhm.
start to like soften towards one another just by having that weekly touch point with each other within our mediation framework where they feel like, okay, I can have a conversation with you without you like, being a crazy person, right? So they sort of rebuild a little bit more of that professional communication, and that can help us sometimes get there. And so I would say I use it as a tool. I agree with you, it can sometimes be helpful. I don't default to it being the first step because I think sometimes it can hurt the conversation depending on their dynamics. So I think it's just that's part of the job is try as a mediator figure out like
Yeah.
when to have this conversation.
Well, I like that. And I definitely agree the 8 hours, because I've been in them as a financial neutral, sitting through them, a total waste and totally unfair. But anyway, I love that approach. And we actually see that with the MDS method. When we're dealing with their finances and the kids' situation comes up or that emotional stuff comes up, it's so good for us to say, now you're going back to your mediator, go back and
Right.
work, schedule your session to talk about that. But let's just keep gathering this data. Let's keep assessing them. So it does diffuse a lot of things and it helps them to keep moving forward. So that strategy I know is proven, and it's great that your practice does that.
Yeah, and what's interesting is, like you said, I think you made a good point. The difference is obviously not what people expect. Like the delta between like, I don't know, 60% versus 50%, it's like, maybe $100 or something. It's not like remotely what anybody thinks
Right.
it's gonna be. And so then we're, once they see the number, they're like, oh, okay, that's fine. Like I'm not gonna die on this hill, right? But again, it's a tool. And that's, as mediators, that's our job is to use our toolkit the best we can. Obviously, you can't force anyone to do anything, right? As a mediator, ultimately, like I can't make you make a decision, but I can try to help you see, through the different tools that maybe it's not worth, fighting this one particular issue.
Yeah.
Yeah.
So let's move on to finances, financial clarity.
Yeah.
What are best practices for that, for people to arrive at mediation the first session? For best practices, what should they have together and how much should they be in the know? Of
You mean
course, we're going to have our opinion.
after they get their portrait is the best
Yeah,
way, if you ask me. I don't know if that was a
Yeah.
lead in for me
I
or
was
for
going
Tina.
somewhere with that.
So I will say high level, the more information, the better, right? I mean, I spend a lot of time with pro se clients information gathering because they're not prepared. And that's just bottom line. I think, but what's unfortunate is I think that happens often with the 8 hour mediations too, that
Yes,
they're not prepared. And now we're spending, you got two lawyers and a mediator for 8 hours in a room. That's like 8 grand
Yeah.
plus.
it
I
is.
mean, that is an expensive mistake.
No,
So,
the lawyers, you said earlier about them getting tired, and not the lawyers are tired too.
right.
They want you to settle. They want to go home too. Yeah.
Right. Oh, well, sometimes I've heard of people having mediations that drag like 14 hours and stuff. I'm like,
Yeah.
Yeah,
what are you doing after
Yeah,
14 hours?
exactly.
Like my brain, that like as a mediator, I can't even function after 14, I'm 14
no.
hours, you know what I mean? So yeah, I will say people are grossly underprepared for most financial
Mm.
conversations. I have some clients, I give them their kind of list, or they, work with a CDFA, they come in, they're like ready. They've got all their stuff. They know exactly what the numbers are. They have all the information ready to go. It saves them a ton of money and time because we're not spending our sessions literally writing down information. Now, sometimes things come up during mediation that maybe they forgot about, and then they have to go back and get more information. And that's part of it as well. Of course, ideal scenario, they go to somebody like you and they come fully prepared, and I guess that would be my answer, that they have the full picture. Is that
Yeah,
always the case or often the case? 50/50, I guess, right? Like depends on
right.
the clients.
Yeah, so many times we'll have someone come and say, well, we have this net worth statement, which is not even in line with how the courts look at how to divide marital assets. It may be a good foundation, but once you start building it out into the division line and how courts look at the value of these various assets, it's a different conversation. I say to so many people, it's almost like learning a new language, right? How
Mhm.
you manage your household and how you're going to divide assets and debt and divorce is two different things. But
Mhm.
it's so true. Back to your discussion about going to mediation without having the documents, and this happens probably 80 to 90% of the time in litigation. We've all seen it, we've all
Yeah.
experienced. We tell our clients, you don't have enough information or documentation to go to mediation, and the attorneys will say, well, we're just going to go see how the other side feels. We're going to go see if they maybe will bring the documents. We're going to go to do these various things other than mediate. But when the client gets there, they're actually mediating.
Yeah.
8 hours later, their attorney's looking at them saying, you either we need to settle this. This is how it's going to play forward for you, good or
Right.
bad, or I need $25,000 to move towards trial. And
Mhm.
so, the system, that is the system that people don't know they're walking into. So to
Right.
prepare and to talk about these issues as much as possible before moving into litigation is so important. So
Yeah, and I will say, like, just gathering data is so, underrated, like
yeah,
the
it
importance
is.
of data, right? Because like I can be in a conversation with someone and, someone brings up, hey, I had this, you know, like unvested stock, right? Like that's one that's always like a gray area, right? Like, because if you're in mediation, you can consider it whatever you want, right? Are there statutes that determine whether something's marital or non-marital? Of course, but you could have two people, if they've been together 20 years and somebody earned unvested stock that's going to vest in 3 months, 6 months, a year, they may view it differently. And we can't have a fruitful conversation on what part of that they consider to be, you know, marital, regardless what the statutes say, if they don't
Mhm.
have a schedule that's clear and they don't understand when was it granted, when is it vesting, what's the schedule,
Mhm.
how does that look, right? And those are the types of data points that I'm like, if you don't have that information, and you don't understand how this stuff works, because a lot of people don't understand
Right.
RSUs and stock vesting, and they've never, they're getting paid that way, but they don't really fully comprehend how it works. And a lot of times the other spouse might have even less knowledge of how it works. So
Mhm.
issues like that, having a financial professional who's sitting down with you, running through it, explaining it to you so you can come into a conversation and negotiation and say, look, I get that technically by statute this is non-marital, but I feel that based on our history together and these points, this portion of it should be coming to me once it vests, right? Like now we can have a fruitful conversation because everyone has the right information. And that is a big, big issue in mediations, that people don't come prepared. And it's the first time we're talking about unvested stock. And now you've got attorneys trying to explain to their client, what is that, right? We don't have a financial professional in the room. So they're trying, like, it's not
Yeah.
gonna work. You're not going to get there.
Yeah.
So if they could have had that conversation with someone like you ahead of time, now they can come in feeling armed to, have a rational, reasonable, facts-based conversation. I think that
Yeah.
would be my big thing, is trying to have facts-based conversations. Like if you want to
Yeah.
prepare for mediation well, you got to like get the emotions out of the conversation, because you're going to do yourself a huge disservice if you're leading with your emotions versus data.
It's so
I
true.
think you just did a commercial for us because that's what we say. We say the portrait is based on data, not your emotions, right?
Right.
Yeah.
All right. Well, that's
Yeah.
funny. Yeah. That's
Yeah. That you we're so committed to that. It's
yeah.
data and verified documents. It's, we want the data, but we also want the documents to verify that data, because you need that as a mediator. Attorneys need that as an attorney if that's where they're going to end up. We're
Yeah.
so committed that is why we developed our company of coming in, going through a very structured process. This is your cash flow. These are your marital assets. These are the documents that support that. This is how the courts will look at those assets, whether it's stock options, real estate, businesses, whatever it may be. It's important, even how they look at home values and equity in the home. And if there's other parties on the home, sometimes people don't even know that, if there's a trust involved or whatever it may be. So just understanding that and not uncovering it midway through mediation, and then having to risk a failed mediation because somebody hit a financial trigger, in the midst of negotiation that wasn't anticipated. So yeah, for sure.
Well,
We're
and
all
that's why I like breaking it up too, because even if we do hit a trigger like that, right, whether on anything, whether it's finances or parenting or whatever it is, we have the option to kind of say, you know what, let's put a pin in this and let's come back. Because, for me, working with pro se clients for the most part, I do attorney mediations as well, but most of what I do is pro se. Like, I feel a responsibility as a mediator, right? Again, self-determination to make sure that these two people in front of me, when by the time they sign the agreement, they have exhausted all options and they feel confident in what they're signing. They may not love every word of what they've agreed to. They might not like be jumping for joy at what's happening, but they can live with it and they understand why they made the decisions they made. And to me, that doesn't happen in an 8-hour pressure cooker. I just don't believe in that framework. I think people need to be given the autonomy and the space to digest what they're doing so that they can ultimately sign on the dotted line at the end confidently, without regret later, and it's a different mindset than, the traditional mediation system, I guess.
And then can you do their marital settlement agreement and file for them? Do you do it
So
all in
in
your?
Florida, we're allowed to draft as mediators. Not every state allows that, obviously, right? So you kind of, depending on the rules. But yeah, in Florida, we're allowed to draft and we are allowed to file. It's not something I personally do. I refer to a legal document preparer for the filing. I don't know. There's plenty of mediators that do it. I just kind of focus on the mediation part. But yeah, technically in the state of Florida, we're allowed to do both.
That's great. Well, this has been a great conversation because we truly here at MDS believe in mediation if you're prepared. And so I love, and I wrote it down, the biggest problem in mediation is your response was most people are grossly unprepared. And I couldn't agree with you more. So being prepared will save you time and money. And it also, I realize when people come through our process, we can advocate for mediation for them because we get to know them. And we do turn their emotions into data-driven responses, which really just prepares you as the mediator and lets you do it in less than 8 hours or in your little spurts of 1 and 2 hours, which I totally back because I think that's the best way to go. So, and another takeaway today here is gathering data is so underrated. A lot of times we have it a 10-step process and we have our portal that's built out. It just tells them where to upload everything. It's all spelled out, right? But it's still frustrating and it's so hard to do, but the response you get from doing that in the long run is so, I'll use your word again, fruitful, because it really is. You have to make data-driven decisions, not emotional ones, and help your mediator by being prepared. So I really love having you as a resource for our clients in Florida. Thank you for
Yeah, and like I said, for me, this is a huge passion of mine. Like my goal is to, revolutionize the status quo of pro se mediation. Like I think the big challenge for people who are looking for this is they cannot find it, they don't understand it, and there's no standardized way of doing this. And so, you know, I am one person on an island. I can only do so much to, improve outcomes for my own clients. But, I've developed a certification program where I'm trying to bring together other mediators who can get certified as Kids First certified mediators, and we can all build this together as a collective of people who sit there and say, you know what? We're in this industry and the system just is not working for a certain subset of clients, and we need to come together and develop a better system that is more standardized and that people understand and that they can find it. Because I think ultimately, if they can find somebody, a mediator like me, and they can find a company like you to get the finances sorted, there's so much empowerment there when they understand what they're doing and they have the space to think through their decisions and they're not under pressure. They can really have better outcomes as co-parents because they come together and make those decisions, and now they can move forward and tackle other difficult things when they come into parenting. And that's ultimately the end goal for me is prevent trauma for children. So the more that we can help parents stay amicable when they're within their actual divorce process, the less trauma there is for the kids ultimately in the long run.
Yeah, and I know that I kind of summed us up, but you said something and I have to jump in here again, Karen. I'm sorry, but because it's so true.
Yeah.
And a lot of times I mean, if Karen and I could put together the money we would have from people just saying, I wish I knew you 5 years ago,
Yeah.
because people that don't make good financial decisions because they don't have the clarity to make those decisions live with regret. And ultimately, they take it out on the kids. And that's where you
Yeah.
hear a lot of the, I can't, your dad won't give me the money, or your mom took all my money, so I can't do that.
Yeah.
That really just affects the kids. So for
Yeah.
us with the MDS method, when you come in and you have financial clarity, because it's true, when you mediate, you're going to maybe not get your A scenario. You might not get your C scenario, but you'll get the B scenario. Everybody's a
Yeah.
little uncomfortable, but then you can move on and then you can put your kids first. And at
Right.
the end of the day, we're all advocates for the kids, not necessarily
Right.
people going through it, because they're the ones that are marrying my kids and your kids. And
Mhm.
that's what's making this generation go around. So I
Yes.
do think working in tandem with the financial clarity and going to a mediator that can help you put your kids first is really a win-win for the family.
Oh, 100%. Yeah, I think, the financial elements of divorce are so often overlooked, I think, as far as the cost emotionally on the children of that financial cost, right? If 30, 40, $50,000, $100,000, 2, 3 years of conflict is spent getting divorced, that's their college fund.
I know, we
That's
say this
their
all the
vacation
time.
with their parents to like build bonds and connections, right? That's their parents' ability to pay their bills and have savings so that they're not a burden later to their kids in retirement years. Like it's a huge long-term impact that
Mhm.
it's had. And I think sometimes people
It's
get so in the weeds of like wanting to win the one small thing, they're willing to like lose it all. And that's sad.
There's so many cases where the $200,000 attorney fee would have paid the alimony number they were fighting over.
Right.
You're
That's
right.
what I'm saying.
All right. So tell our
Yeah.
viewers how they can find you, because I'll keep talking.
Yeah. So my website is floridadivorcemediation.com. That's my business. And again, Tina Keys. I'm based in Orlando, Florida, but I work remotely all over Florida. And the Kids First program, like I said, we're always looking for mediators that share our vision. So that's kidsfirstmediation.com.
Excellent. And if you're looking to understand your marital finances before making major decisions, visit us at mydivorcesolution.com. With the right information, you can move forward with confidence.
And if this episode resonated with you or someone you know going through a divorce, please share it with them. If you would like some follow-up information or you have questions or comments about anything that we said today, whether you agree with us or not, please leave them and we'll discuss them next time.
Sounds great. Thank you again, Tina. It's a great
Thank you.
conversation.
Thanks for joining us on another episode of We Chat Divorce. We hope this episode was informative and supportive on your divorce journey. If you're looking for more support for navigating divorce with confidence and clarity, head over to mydivorcesolution.com for more podcast episodes, divorce events, and resources for your divorce. We'll see you back here for our next episode.